As we've seen in our discussion of the fiduciary duty of directors, service as a director carries some risk that a shareholder who's unhappy with the decision of the board may pursue a claim for breach of duty and potentially hold the directors personally liable for whatever damages were caused. That's what we saw in the Van Gorkum case. And given this risk, then why would anyone agree to serve as a director? The average comp for a director of a Fortune 500 company is a little over $200,000 a year. And that may seem like a lot of money for just attending a handful of meetings every year. But considering how large the potential damage claims could be, is it really a good trade-off? Who would take the risk for $200,000 a year to face millions and millions of dollars of potential liability? They would only do that unless the risk of liability was indeed very, very small. This, at least, is the thinking of the state legislatures that have adopted both exculpation and indemnification provisions in their state corporate statutes. Not satisfied with the deference that courts have given to directors' decisions under the business judgment rule, especially after the shock of the Van Gorkum decision, legislatures adopted exculpation to address directors' fears of personal liability. So let's look at what they did. Let's look at the statute. What does it actually say? Well, here we have Section 102B7 of the Delaware General Corporation Law. Most state statutes, I believe all state statutes, have similar provisions now in their corporate statutes, allowing corporations to adopt provisions that effectively eliminate personal liability for certain breaches of fiduciary duty. Right? And here in particular we see in Delaware a very straight statement that says you can have a provision in your charter that eliminates or limits the personal liability of a director for monetary damages for breach of fiduciary duty, subject to some exceptions. Right? Now, make sure you realize that this is simply a provision that authorizes a particular charter provision. So it is not self-implementing. Right? The corporation, in order to have this limitation on monetary damages for its directors, actually has to do something. And what it has to do in order to opt into this kind of protection is change their charter. Now remember, what it takes to change a charter, it requires usually shareholder approval. Right? And so that was an artful way of saying you can have this protection provided you get your shareholders to agree that that is what they want. They have to agree in order to amend the charter to adopt this provision. Let's take a second and look at a typical such provision. Here's the one from Excellic Technologies, and Article 9 of the charter is the implementation of 102B7, and it says simply, to the fullest extent permitted by law, a director shall not be personally liable for monetary damages for breach of duty. Okay? And then it goes on to talk about amendments. But this is the operative sentence, right? So really all it does is say we're doing whatever the law has enabled us or allowed us to do in terms of protecting directors from personal liability. So it really just sends us back to the statute to see what it is we've agreed to do. And what the statute tells us is a corporation is allowed to shield a director from monetary damages for all breaches of duty except, and there are four important limitations. All right. But before we get to those, just a quick comment is you notice it's for monetary damages. It does not exclude, quote, liability, or does not eliminate the possibility of someone bringing litigation in order to seek injunctive relief. Right? And why that is important is because most litigation brought against directors involves some form of plaintiff's attorney who's functioning on a contingency basis, someone who's seeking either a class action or a derivative case that allows for the recovery of attorney's fees. Since injunctive relief would also allow for the award of attorney's fees, this provision does not eliminate all incentive. It eliminates some, but not all incentive for plaintiff's lawyers to pursue claims against the corporation for breach of duty, or the directors for breach of duty, since if they get an injunction, they can also still get the reward they're looking for. But then let's focus, if you will, on the four exceptions. Right? The first one, probably the most significant, is it carves out duty of loyalty breaches from the exoneration or the exculpation. That's the big one. Next, we have breaches that involve intentional misconduct, or I'm sorry, omissions that involve bad faith, so actions that are not in good faith, or which involve intentional misconduct or knowing violation of the law. All right. A couple questions here. What does it mean to lack good faith? What constitutes a violation of good faith, or what constitutes bad faith for these purposes? That's a question we should consider. And then let's consider the other line drawing issue of knowing violation of law. Right? You can imagine someone who is a director who decides to perhaps push the envelope, take risk, be perfectly rational, and make a good business decision that, let's maybe push the line on whether we're going to cross the limit on some kind of pollution, some kind of other action that has criminal implications, but was a rational risk-taking decision by the part of the corporation. And the question is whether that would push you out of the right to be exonerated. Those are good questions. We learned earlier about illegal dividends and exceeding your surplus. So that's covered by subsection 3. And then finally, subsection 4 says if you personally benefited improperly, well, that's not something you can be indemnified for. So you can't embezzle funds, get sued, and then be indemnified for the money you embezzled, since that would be certainly a circular result. Okay. I think that as a practical matter, what we have to worry about based on these 4 exclusions, if we were representing a director, are not the risk of illegal dividends. We know how not to do those, and not improper personal benefit, because we also know how not to do that. And also the idea of intentional misconduct is probably not scary, since for the most part I think we would feel comfortable knowing how to avoid doing that. But what it leaves us exposed on is when is it that a case of loyalty may be brought, because we can still be exposed for monetary damages for that. When can a case about something being not in good faith be brought? Again, because that's still something that exposes us to monetary damages. And finally, this idea of the knowing violations of law, that line-pushing concept I just mentioned. Right? Since we still have those 3 exposures, right, this exculpation power, as was implemented in this exculpation clause in our charter, probably doesn't get us to the point where we want to be, where we're willing to make that trade of getting a $200,000 fee in exchange for taking on the risk that we might be personally liable in some kind of shareholder suit. Right? We still need more. And where might that more come from? Well, we look at another section of the statute, and it talks about the power to indemnify. Or if we look at another section in our charter, right, the next section in Excella's Technologies Charter, it talks about indemnification. And it says, right here, to the fullest extent permitted by law, the corporation is authorized to provide indemnification. Now, what's that all about? What is indemnification? Well, I think we have to start by parsing this section 145. And very similar sections show up in other state statutes, but this is Delaware's statute. And let's start with, I think the easiest place to start is paragraph C and see what it says. All right. This section tells us what a corporation must do. This is actually a mandatory section. It is not optional. It's not enabling. It's a right that's being granted to directors and officers that is not optional for the corporation. And what it says is that it's mandatory to indemnify a director for the costs of defending a suit if the director has been, quote, successful on the merits or otherwise. This is the very important phrase, right? So if you win a case that was brought against you or against the corporation involving a breach of duty, you're entitled by statute to have your attorney's fees and other costs paid by the company. Right? That's what the statute says. But the tricky question is, what does this or otherwise language mean? right? So does that mean you're entitled to indemnification if you settle the case, right? And the answer there is no. You're not entitled to it. You might be able to obtain it, but you don't get it under this section as a mandatory provision. But what it means, though, is that if you don't win on the merits, but you win, for example, for procedural reasons, like the statute of limitations has run, or their plaintiff loses because they don't have standing to bring the case, or something like that, that still entitles you to your expenses back under Section C. All right, so that's the beginning of indemnification, the mandatory part. Let's then look at the permissive part. Right? If we look at paragraphs A and B, right, we note that they both start with the phrase, a corporation shall have the power to indemnify, right? So it doesn't say the corporation shall indemnify, so that's different from C. It's not a mandatory clause. It's simply an enabling clause. It says that if the corporation elects to do this, it's allowed to do it, right? This is establishing the authority to provide indemnification, right? This indemnification is not mandatory. A corporation does not have to do it. All right? So if a corporation is going to do it, we have to look elsewhere for that. And where would we look? Well, interestingly, sometimes you see it in the charter. This actually charter does not implement the power, it just simply states it over again, right? But you'll often see in bylaws, and then most commonly in some form of indemnification agreement, a contract that's being made between the corporation and the directors and officers, where the corporation implements or takes advantage of this authority that it's being given under 145A and B, right? So this is the grant of authority, and the actual implementation has to be found elsewhere, either in charter, bylaw, or some form of agreement. Okay. Now, it's important to look at A and B and contrast them, right? Because there are very significant differences between the two, right? It is important to realize that A covers the cases where the suit is being brought directly by a third party against a director, and paragraph B talks about those cases that involve so-called derivative suits. Now, we're going to talk more later in another unit about the differences between direct suits and derivative suits. But basically, the idea is that for some claims, the plaintiff is being required, right, to bring their action in the name of the corporation rather than on their own behalf. Okay, that's a derivative suit, when you're required to bring the suit in the name of the corporation rather than on your own behalf. And the logic of this requirement is that where the harm suffered is suffered first by the corporation and then only indirectly by a shareholder because they happen to own part of the corporation, then the recovery should go to the corporation, which would then, if once it recovers whatever damages it's entitled to, would benefit its shareholders pro rata because they're still owners of the corporation, rather than have the money go directly to the shareholder, right? And so this is often a very slippery and tough concept, and as we'll see, it's not as clear as you would wish. But an easy case, just to put it in your mind, would be a claim for an accounting for an illegal profit, a corporate opportunity, right? So any harm that shareholders suffered because a director took a corporate opportunity, made money they should not have that actually belongs to the corporation, would only indirectly affect the shareholder. It's not something that impacted them personally or individually. It impacted them as one of a group of people who shared in the ownership of the corporation, who was made less valuable because they didn't have this opportunity, right? And so the courts will say, no, you can't go recover your little piece of that lost opportunity, that ill-gotten profit. Instead, what you have to do is, on behalf of the corporation, go get the whole thing back, put it into the corporation again, and then get your benefit by reason of the pro rata share of that asset that now belongs to your entity, rather than getting it directly, right? And so that's the difference, right? And the statute treats suits that are brought directly, where the shareholder gets to grab their damages themselves directly, versus those cases where the corporation is the one who's going to be the one that recovers, so-called derivative suits. That's for B. Direct A, derivative B. So if you're dealing with a derivative suit, so we're under B, right, what are the issues? Well, the statute says that a corporation can indemnify for expenses as opposed to for the actual recovery, right, for the damage award, unless, right, the director was adjudged to be liable, right, and adjudged, what that means is was found liable in an actual decision of the case, right, by court, as opposed to being held liable in a settlement, right? So you can still get expenses if you settle, but you can't get expenses if you are found to be liable in a court proceeding, right? Or, right, so this is the other reason why you might not get your expenses recovered in a derivative suit. The director lacked good faith in what they did, or did not have a reasonable belief that they were acting in the best interest of the corporation. Right? And we'll see that phrase again in paragraph A. That's an overarching standard for indemnification. If you're acting in bad faith, or you just could not reasonably believe that what you were doing was in the best interest of the corporation, so you were a rogue bad guy or something like that, that kind of standard, you're not entitled to indemnification. But as long as you thought in good faith that what you were doing was appropriate, you can seek your expenses, so your lawyer's fees basically, even if you end up settling a claim in a derivative case, but you cannot, right? So you get nothing, no expenses and no recovery if you end up losing the actual litigation. So notice there's a very strong bias in this dynamic, in this section, towards settling. Right? There's a real upside for a director in that they at least get their attorney's fees paid if the corporation has elected to fully utilize its power under Section B. Okay. Now, if you're dealing with a direct suit, the rule is slightly different. Right? Here, the statute says the corporation can indemnify for both the actual damage award or actual recovery or penalty that the person is being asked to pay and expenses, unless, and here we see the same standard again, the individual who's seeking indemnification fails to meet the standard of good faith or reasonable belief, right, as to the best interests of the corporation and their actions, or if it involves a criminal case, they had no reasonable grounds to believe that what they were doing was, they had no reasonable cause to believe what they were doing was unlawful. Right? Now, when a director is being sued, often the most significant and most crippling aspect in terms of a cost and what they most need indemnification for is for attorney's fees. Right? Even if they're going to win, it can be very expensive to defend yourself. And sometimes that defense can take years and years and years. And so unless you're able to fund those lawyer's fees from some source other than your own pocket, that would be a very significant deterrent to wanting to be a director. Because the idea is, even if you win in the end of the day, you would be financing this very expensive litigation out of your own savings, and that would be very unattractive. And so a very important provision in the statute, and a very common provision in indemnification agreements, are one that deal with advancing of expenses. And paragraph E is the provision that authorizes that. So it says the corporation can agree to front the money for expenses, provided that there's an agreement to pay it back if it turns out you weren't actually entitled to it under the provisions of paragraphs A and B. Right? Okay, that's a very important provision. Okay, but then the question is, so we found out that there is the right or power to indemnify. All right, and let's assume the corporation did as ours did, authorizes and then ultimately implements full indemnification. Right? We still have limitations, right? We still have limitations that relate to good faith. We still have limitations that relate to reasonable belief about best interests. We still have limitations that say you can't get paid if you are found liable. for the actual damages in a derivative case. So there's still holes, if you will. And the question is, can we go further? Right? Is there a way to fill those gaps even further? And some hope gets given by the provisions of paragraph F, right? So even if the power to indemnify under limits set forth in A and B, what does it mean to say that those powers are not exclusive, right? Well, there was for a while great hope that that meant that basically you can say you can indemnify for everything in an agreement. But the courts have generally said no. There is a public policy cap on how far you can go. This was not a just broad-based delegation to do whatever you want. So no, you may not indemnify for bad faith. No, you may not indemnify for the rewards given in an adjudged liability for derivative suits. Right? So if the corporation recovers in its own right and it gets a judgment against you, that's not something that courts have allowed people to be indemnified for under this notion of non-exclusivity of A and B. But what this really does tell you is you can be quite aggressive in defining within the confines of what A and B say the rules, the procedures, the decision-making processes in your agreements and make them extremely favorable to your directors. But I think most importantly, perhaps, is G. Right? And this basically says that a corporation has the right to buy insurance, and to buy insurance that covers claims that even the corporation would not be allowed to directly indemnify for. Right? And so this has been read differently than the exclusivity section, or not exclusivity section, I probably should say, to say that if you can buy it, you can get it. Right? That there is no limit to what insurance you can get on behalf of your directors, and it is very typical for a corporation to buy insurance for their directors and to pay the premium. Right? So the only question is, well, what is it that the marketplace, as opposed to the law, does not provide? What things do insurance companies simply refuse to provide coverage for? And there are a list of things that are typical. So, for example, if you have personal liability for a violation of certain statutes, like the environmental protection statutes or securities regulation statutes, often insurance policies carve those out as things for which you can recover insurance, while at the same time those could be liabilities or penalties that are covered by paragraph A, right? So, right, since that would be a claim by a third party against the director, not a derivative claim, and as long as they were acting in good faith and without a reasonable belief that it was not in the best interest, they probably would be covered by the indemnification provisions. So while insurance can go very far, it can also contain gaps that the indemnity provision might cover. And so the bottom line is that directors are going to want it all. They're going to want exculpation, because that gets them out of monetary exposure for breaches of the duty of care. They're going to want indemnity provisions, because then that takes care of the other gaps, provided that they're, so it covers duty of loyalty, it covers other gaps in the exculpation, so long as we are still in the world of good faith and reasonable belief, right? But the point is that when you bundle it all together, exculpation, indemnity provisions, indemnity agreements, and insurance, what they're looking for is to cover the waterfront as much as they possibly can. All of which means the bottom line is that despite Van Gorkum and the surprising judgment there where they held the directors personally liable for $23 million, which was the ultimate settlement, personal liability for directors is in fact very, very rare. Happens almost never. And that is why people are still willing to put themselves out there, quote, on the line for $200 grand a year.